conditions were adequate to grant the relief that the court ultimately granted. But the highlighting of the suo motu assumption really, to my mind, is a diversion, because even if there was no suo motu reference, the matter could still have been taken up, should have been taken up, and this was the classic situation in which the Supreme Court was confronted with almost all organs of the state, all state authorities that have a role to play in the conduct of elections, denying their mandate, or saying that they would not hold elections. Whether it is provision of funds, whether it is provision of personnel, every single institution, including the Election Commission itself, that dragged its feet for weeks, quibbling over readings, quibbling over jurisdiction, was clearly determined not to hold elections. So that then raises the question that when the powers that be in the state, in our state, have decided to defy the Constitution, where should we stand? What should be our stance, yours and mine? Do we just go along with it? Do we just accept that assertion of power? Or do we say no? We will stand up, we will speak against it, we will act against it, and we will deny this most blatant violation of the Constitution and not get caught up with ancillary questions regarding constitutional benches and who should have been in the bench and who should not have been in the bench. There is nothing clearer in the Constitution than the 90-day limit. Elections have to be held no later than 90 days after the dissolution of the Assembly. So that is the long answer.
Thank you, sir. मेरा दूसरा सवाल फैसल साहब से है। फैसल साहब, एक तो फॉर द ऑडियंस आप थोड़ा सा एक्सप्लेन कीजिएगा कि वैल्यू ऑफ कॉन्स्टिट्यूशन क्या है, और दूसरा ये कि the unrest in the public जो है अभी apparent, do you think that the constitution is able to adequately serve as a means to resolve any political conflict in present Pakistan?
Topic today was US Constitution Act, and typically it was a lawyer fashion act about the answers both saying yes and no. So let me begin with the no first. So why it doesn't work. So there is a famous American guy called Allama Iqbal, and he wrote a speech called The Spirit of Liberty, Spirit of and his point was that liberty lives in the hearts of men. And as so long as it lives there, it needs no court, no law to protect it. And if it dies there, then no court, no law can protect it. So अगर बात ये हो रही है कि इस मुल्क में कानून होगा या नहीं होगा, तो वो एक फैसला जिसके ऊपर हर शरीर लाजिम है वो खड़े होकर वहाँ पे सिर्फ यही कि आई कहता है तो फिर आई तो फिर इम्पोर्टेंस है आई ये अहमियत है कि भाई आप इतने सालों से आपकी जनरेशन जो है उनका एक इत्तेफाक है कि जो हमारे मसाइल हैं उनको किस तरह से हल करेंगे, हम इस तरह से बैठेंगे, हम इस तरह से बोलेंगे, हम इस तरह से मिलेंगे, हमारी अदालतें जो है वो इस तरह से एक दूसरे के फैसले देगी, वो एक तरह से रूल ऑफ द गेम है। इन रूल के बगैर, कवानीन के बगैर आप एक दूसरे से बात नहीं कर सकते। जब आप बात नहीं करते तो फिर एक तरीका होता है बात करने का, वो बेसिक रूल जो है वो कॉन्स्टिट्यूशन है। अब आपका सवाल जो आता है कि इस कॉन्स्टिट्यूशन केपेबल ऑफ हैंडलिंग दिस सॉल्व, द आंसर इज विल सी। ये अगर कोई चाहे कि उसने इसका जवाब नहीं देना या आइन को नहीं आगे चले, एक आदमी कहे कि बस कानून मेरे पे लागू नहीं है, मैं इस वारंट को पर नहीं मानता, क्या बात दूसरा कि नहीं है, ये कानूनी सवाल है। एक आइन की धारा है कि मेरे ख्याल से तो इलेक्शन नहीं हो सकते हैं, हालांकि कॉन्स्टिट्यूशन में लिखा हुआ है कि इलेक्शन होने चाहिए। उस पॉइंट पर मैं वैसे वाजे कर रहा हूँ, एक समाज सभा में दो बात होगी। I think there is a simple point that कि आप कोई भी If they are willing to accept the rules of the game, that is always a fixable problem. And what we find out in the case of government, whether people are acting in good faith or bad faith, or whether there are people or institutions who would rather than the slightly burn than let it progress in peace.
Thank you, sir. Anissa, my next question is to you. प्रोफेसर साहब की बात को आगे लेके चलते हैं तो आपको क्या लगता है कि हमारे कॉन्स्टिट्यूशन में कोई अमेंडमेंट्स करने की दरकार है या इन दिस फॉर्म में जैसे टू अपलोड कॉल्स में बैठेगा?
I think the answer to that question lies in what are fundamental rights and who gets to define what fundamental rights are. And under our constitution, it's the constitutional courts that define what fundamental rights are. Our constitution is not particularly repressive text when it comes to women's rights, when it comes to human rights. But we do find that the living, breathing constitutionalism that we often see in other cases, somehow when it comes to the interpretation of women's rights, stops breathing. And one of the basic fundamental rights that is guaranteed to citizens under our Constitution is Article 25, and for the non-lawyers in the audience, I will go through that. Article 25 guarantees equality of citizens and equal protection of the law. Article 25(2) says there shall be no discrimination on the basis of sex. And Article 25(3) allows the state to make special provisions for the protection of women and children. So, in that sense, if you look at our sexual harassment laws, they are premised on the fact that there is equality of citizens, because women need the protection of sexual harassment law in order to partake in the exercise of democracy, in order to work and exercise their right to work. And so it makes sense that our parliament passed a law, the sexual harassment law, in 2010, and it set up a whole system for catering to sexual harassment things. However, in 2018, there was a High Court judgment which essentially said that through the application of contractual principles, it interpreted the fundamental right to be protected against sexual harassment, and said that it does not count as sexual harassment because आपकी जो sexual harassment है, it's not under or pursuant an employment contract, then ये sexual harassment है. या अगर आपकी harassment workplace पर नहीं हुई, जहाँ लिखा होगा कि ये workplace है, तो that is also not harassment. Similarly, 1 year later, there is another judgment which says unless sexual gratification is not motivated by the use of conduct, then that's also not sexual harassment. Anyhow, that confusion and loopholes in the law were resolved through efforts of parliamentarians, and a new federal law was passed in 2022, which goes on the Constitution Code. And then again, just 2 weeks ago, we have another High Court judgment which says that the whole edifice on which the sexual harassment law is based is the Ombudsperson's office, and that judgment now puts the constitutionality of that office in question because, outcomes. So, I think and the judgment was just a simple judicial review case in which a decision of the ombudsperson was challenged, and it could have been struck down by, the usual grounds of judicial review, like illegality, irregularity, procedural impropriety, etc. But no, the Honorable Court strikes down the entire law. The law titled the Enforcement of Women's Property Rights Act 2020. And when you would think that if there's a judgment striking down a law titled the Women's Property Rights Act 2020, it would have some discussion of, as I earlier said, one of our, the most basic fundamental right, which is Article 25, equality of citizens, and it would have some discussion of 25(3), allowing the state to make special provision for women. But what the judgment does say is that Parliament, in its zeal to protect rights of women. So I find that wording by the judges very interesting, that Parliament, in its zeal to protect rights of women, passed a law that was in violation of constitutional principles. There was enough time and judicial ink to talk about Montesquieu, about Lord Acton. There was enough time to talk about Aaron Barak, but there was not enough time to discuss women's rights, or Article 25(3), or CEDAW, the Equality Convention, under which this law was promulgated. And I think, in answer to your question, I think that when it comes to the enforcement or interpretation of fundamental rights that are such a crucial part of our Constitution, the fact that judges do not want to engage with women's rights